Occasionally, one or more parties will make a mistake regarding their contract. In this case, the courts may provide remedy, but the mistake must undermine the basis of the contract and destroy consensus. The mistake must involve confusion with the terms, significant circumstances, the identities of the parties, a matter of fact, a future event, and the law significant of the contract. However, when careless party is responsible for their own mistake or it is a result of their own negligence, they will not be able to receive remedy. In the 97011 Ontario Limited versus Cornell Engineering case, the mistaken party could not seek recession or rectification because they had contributed to their own mistake.
Cornell Engineering Co. is a company owned by two businessmen named Bimboga and Stevens. Bimboga had a 49% stake in the company, which he had sought to sell. Stevens had suggested that Bimboga should sell the stake to the former apprentice McDonald. Before Bimboga agreed to sell his stake to McDonald, he wanted to make sure that he was qualified to help take over the job. Bimboga had requested that Stevens read over all of the terms of the contract, which included a buyout clause for Bimboga leaving the company. Stevens, however, only read the first page of the 11-page contract and had never had the knowledge of knowing the clause. Bimboga took Stevens to court, which Stevens eventually won since the termination clause had not been discussed. But Bimboga appealed the verdict, stating that Stevens is a sophisticated businessman who was told to read the contract beforehand. Therefore, the court decided to overrule the original decision and then side with Bimboga.
Hey Stevens, I just thought I'd want to let you know that I don't want to be in the company anymore.
Oh, you should look into my old apprentice McDonald. He would be a great replacement for you.
Well, I just want to make sure if he's qualified enough to take over my position in the company first. I created a contract that I think you should look over regarding me leaving the company.
Yeah, for sure. No, I'll give it a good read. You know, I think I probably only need to go over the first page, whatever, it's all good.
I didn't get my release clause that was in the contract, so I gotta take you to court and ask Stevens.
What release clause?
What release clause? You should have read the contract.
I did read the contract.
No, you didn't, apparently.
Order in session for Cornell Engineering Company versus Ontario Limited.
My client Stevens did not have knowledge of the clause, therefore he should not be held accountable.
Checks out.
I'd like to order an appeal. Bimboga should receive financial compensation because Stevenson did not read the entire contract. Being a sophisticated businessman, Stevenson should have known to read the entire contract.
After reviewing the appeal, we find that the mistake was Stevenson's in not reading the entire contract, so we order in favor of Bimboga to receive compensation.